So, good afternoon. Hello, everyone. My name is Cassandra, and I'm so happy that you could join us for the Heart Gallery's monthly webinar, Legal Process of Adopting from Foster Care. We are so thankful that you could join us today, and we're very excited to have JB Bobbitt, Associate Attorney at Laura Dale and Associates, with us today. JB has extensive experience with adoptions and suits affecting the parent-child relationship where child safety is at risk. After this presentation, we will have some time for Q&A. If you all have any questions, please feel free to write them in the chat as I'll be monitoring them. Or you can also wait till the end and ask it directly. And then just to let everybody know, I'll be following up with everyone after the training through email. But for now, please help me welcome JB. So thank you, JB, for being here today.
Well, thank you so much, Cassandra, and thank you all for being here. My name is JB. I've been an attorney in Texas for about 15 years. The majority of my practice has centered around child welfare or other, CPS-related cases, and this is a subject that I'm very passionate about and happy to be able to go through my presentation today. I'm going to we're going to be talking about the legal process of adopting from foster care in the state of Texas. Just to be clear, nothing I provide today or any information should be relied upon as a substitute for competent legal advice by a licensed Texas attorney. But I do want to go over these things, and I'm trying to get through so we have some time for questions if there are any. So I think the first
And
thing
JB, just real quick,
yeah.
we're seeing your presentation with the notes section.
Oh, okay. Did I share the wrong screen?
Yeah, I
I am
think so.
not an expert in PowerPoint. So here we are. There we go. Is that right?
Yes.
Okay. That should do it. Okay. Okay. So as an overview of the legal steps, all adoption decisions at any point are controlled by the family code. And the primary consideration under Texas law is to prioritize and focus on what's in the best interest of the child. Now, what that actually means or how that's defined is really a decision that's ultimately going to be made by a judge or a jury, depending on the circumstances. But that's the primary consideration. All of these cases involve very complex legal and emotional circumstances. And I say the emotional circumstances because that can often be a really strong driving point for any of the stakeholders in the case, whether that's biological family or the foster family that is involved in the case. Now, foster care is not a term that is actually defined in the Texas Family Code, or foster parent is not defined. Foster care is really a status, and it can mean one of two things generally, that whether the parent, and it's referring to a child that is no longer has their parental rights that either temporarily intact or permanently terminated. So I put here the idea where the parental rights are still intact, where mom and dad are still involved in this legal process. They have rights to receive information, and that those are considered legal risk placements by the department or by a court. And then where parental rights are terminated, then that child would be legally free. And that is a super important distinction to understand for any person who's entering the foster care space, is that if you're accepting placement of a legal risk placement, then the ultimate outcome of that case is at a very high risk, meaning that really the child doesn't know whether or not the child is going to be returning home to mom or dad or to a relative, and the ultimate permanency goals aren't known or even really knowable until a judge or jury makes that decision. Once the rights are terminated, the child's considered legally free, and then the decision of adoption or other permanency goal is the only consideration to be had. So the process really starts to adopt from foster care with finding an agency. And I've kind of looked it up. There are, what I could gather is there's over 240 licensed agencies in Texas that operate in Texas. And there are different types of agencies. And I think this is an incredibly significant decision that is made by foster parents. There are historical agencies that go back to the 1800s, like the Buckner Agency is now a vestige of what was once considered an orphanage. There are national agencies that are, in multiple states and operate in different states. There are international adoption agencies that facilitate international adoptions. I will say that that's a much more complex process, in my opinion. And then there are faith-based agencies there that are focused on different, and have different religious backgrounds and support for their families that are working with them. There are community-centered agencies which have sometimes a different degree of tolerance or acceptance for non-traditional families. And I really always encourage foster parents to really choose wisely when beginning the process to become licensed, because you want to have a good fit. And some of these agencies have additional training requirements, and which are helpful and beneficial to entering into the foster care space. And ultimately, transferring agencies is a possibility, but if it should really be avoided. You want to make sure you've got a good fit. My recommendation is to interview with 2 or 3 agencies and know that while they may not be one or two may not be a good fit, you should be able to find one. In Harris County, we have, hundreds of agencies that are based out of here. So, now, when should you get licensed? You should start that process when you are ready, when your family is ready. You should talk to your husband or partner. You should talk with your children. If you have biological children, you should talk with your moms and dads, because potential, foster grandparents, they all need to be involved. This is a family process. And then you need to start with the applications. After you've selected the agency you want to go with. They're going to conduct interviews and have required training. Some agencies require just the bare minimum standard for training, and some agencies require additional hours of training. Some of those trainings are in person. I think during COVID, a lot of them were able to be modified to be virtual trainings. You'll have to pass background checks, and home studies have to be done both pre and post placement. And then once you're through that process, then you're licensed, then you will begin the process of matching, which is a big part of what Heart Galleries is involved in and helping to find homes. A home study itself, we'll talk about that a little bit. You're going to need to have your identification documents. You're going to need to provide your marital status. If you are married, then both husband and wife need to be part of this process for a home study. I could tell you that I have seen before that it was identified years after a child had been in a home that the foster mother was married and was estranged from her husband. And because the husband was not part of the home study and was not being considered, that disrupted the entire adoption process for that child. And the foster mother really felt strongly in that situation that, she was not morally going to get a divorce despite not having talked to her husband in 18 years. But your marital status matters when going through this process. You've got to demonstrate financial stability, which doesn't mean you have to be extraordinarily wealthy. You just need to be, stable and not, in a financial circumstance that would not allow you to support a child. You got to pass your home safety inspections. These are really important because things like your hot water heater need to be turned to the correct temperature. I've seen situations where that was a problem, and a child got injured, and it was just an oversight by the home evaluation that the home had 2 water heaters. One of them didn't get turned down properly, and a child got hurt. So these are all seem tedious, but they're very important. Fire extinguishers and smoke detectors need to be installed. Everyone in your home that is over the age of 14 is going to have background checks and interviews just to make sure that the whole family is on board. There are legal authorities in the family code that set out these requirements. Once you're licensed and you have matched with the home, then you may be looking at a legal risk placement. And a legal risk placement is going to involve necessarily the termination of parental rights, should the child get to adoption. And if you're not terminating parental rights, to be clear, there is no adoption possible. And that's a firm barrier. To be clear, when you're talking about parental rights in the state of Texas, they are constitutional rights, established by the United States Supreme Court, the Texas Supreme Court, and statutorily, these rights are protected by a very high burden of evidence. The burden is clear and convincing of both a legal ground that forms the basis for the court to terminate rights, as well as a finding that it is in the best interest of the child to terminate those parental rights. So one of the key factors, no matter what, in a termination case is going to be that a child has a potential adoptive placement, because the court has to consider the future plans for that child. And if a child doesn't have a potential adoptive home, it becomes a really hard argument to make that the court should terminate parental rights, otherwise orphaning that child without a future plan. And keep that in mind, because I think it comes up later as we talk through this. As far as the legal grounds for termination, they're set out in the Texas Family Code, starting in section 161.001. First, there's a voluntary termination, and that means that a mother or a father has decided to give up their parental rights by their own choice, and they have to do that, they have to execute an affidavit of relinquishment. It has to be signed in front of 2 witnesses and a notary. There's an exception made for circumstances where a parent is incarcerated. However, in either case, the execution of an affidavit of relinquishment is a very, very sensitive process. And if it's not done correctly, then the relinquishment will not be valid, and it won't matter whether they signed it or not, as far as this voluntary termination is concerned. I think that this is an important stopping point to talk about the role of a foster parent in this moment, because in my experience, there are many voluntary terminations that result from a biological parent having a positive relationship with a foster parent. If you take a perspective of what a biological parent is going through when they've had their children removed from their home and are going through this legal process, they oftentimes don't know where the child has ended up. They don't know the foster parent's face or name or home. And if you want to know what the context of that might seem like, you could do a quick Google search of foster parent Texas and hit the button for news. And you'll find that the news stories are never positive. There's very rarely a newsworthy story about how amazing foster parents are in Texas, which I think they are as a whole. But most of the news stories are very scary, terrible circumstances. So in the event that a foster parent and a biological parent can somehow meet, connect, get an understanding mutually about what's happening for this child, then you usually will find ways through that a voluntary relinquishment might actually occur, a voluntary termination. And I think that's a big part of the role if you're going to look to adopt through foster care where there's a legal risk placement. Now, alternatively, you have involuntary terminations. This is hard standard. It is the equivalent in the Texas Family Code of the death penalty. There's no more severe consequence in the law under the Family Code than a termination. A termination is final and forever, and it requires this clear and convincing standard of evidence. When you're going to put someone in jail, then you have to meet a standard of evidence called beyond a reasonable doubt. if you ask me what the difference between clear and convincing evidence is and beyond a reasonable doubt, I think they're very similar, if not almost the same. And so the legal grounds can stem from abandoning a child for a period of 6 months, without expressing an intent to return, all the way through really horrendous acts, which some of you that are here I know may be familiar with. Um, Hard cases and very emotional. The timeline for a termination suit, statutorily, it's 1 year. I don't think I've seen a case get resolved within a year in a very long time. Maybe that's not always the case across the state, but generally speaking, it's common to see most Texas courts grant extensions, which can vary from 6 months to up to another year. In some cases, in certain circumstances, they can last several years prior to a finalization of or resolution to a case. I will say the role of a foster parent, again, I think is incredibly important through this process because and we're going to talk about that in a minute. So once you have parental rights terminated, then a child is legally free for adoption, and you can start talking about what the adoption process looks like. I put this together because as a comparison of when CPS, or the Texas Department of Family and Protective Services, is the managing conservator, foster care, or circumstances when parental rights have been terminated when TDFPS is not the managing conservator. When CPS is the managing conservator, parental rights get terminated, then the case shifts to adoption prep, which is an entire separate division of the department. Those workers have to take some time to get familiar with the case and begin working on the case. And as a foster parent, you'll need to work with them as they familiarize themselves with the child, start to visit the home. But you will then be looking at starting to the process. And so one of the first things is to select an attorney. That's a choice that each foster parent can make. You can get, I suggest you get recommendations from your case manager when you're at that point. And this is not, we're not talking about in this point a contested situation or circumstance. So there's a subsidy available to assist with the fees for an adoption. And there's a lot of attorneys, at least in the areas that I work, that will work for that subsidy. And so I suggest working with your agency or with CPS to identify an adoption attorney that helps with subsidized adoptions for foster parents. There in Harris County and several courts, there are free or low-cost amicus attorneys, but in every case, the court will require that there's an amicus attorney appointed to assist the court with the adoption. Amicus, or amicus is how we say it in Texas, means friend in Latin. And their job is to go out and assess the home, read the documentation that's filed, and to then basically approve of the adoption or oppose the adoption. Foster parents also have the job of reading the redacted file. That's a job of the adoption prep caseworker to obtain a copy of the redacted case file from CPS and provide it to you. In the old days, it used to take sometimes 6 months or longer. Sometimes it takes less time. Some caseworkers I've seen just provide a disc to the family. Sometimes they don't, but you have the ability to waive the reading of the redacted file. However, I would never really suggest that because there may be information that's really important for you as a foster parent to know about this child and to know about the family history, from health information or just circumstances relating to the trauma they may or may not have experienced. Next, the department will need to sign a waiver and consent to the adoption. When CPS signs the waiver and consent, then that is really the final document, because that is them signing off and telling the court that we approve of this adoption as the child's managing conservator. Another document that will occur at the same time as the waiver and consent is sometimes it could happen before, but is the ICPC affidavit. And hopefully this will never be a problem, but it could be. An ICPC affidavit stands for the Interstate Compact on the Placement of Children. And this is a statutory, meaning it's in the family code, requirement that if a child has moved across state lines, that there was compliance with certain state laws that prevent children from being moved across state line for the purposes of adoption. Generally, by the time you're at adoption with parental rights terminated and CPS is the managing conservator, this will not be a problem. If ICPC becomes a problem, then you're going to need to let the lawyers handle it. It's a big problem. Finally, while this waiver and consent and ICPC affidavit is being finalized, the Department of Family Protective Services will do what's called negotiate subsidy. It's oftentimes a huge misnomer what that actually means. It's not like a car dealership where they're sitting down and negotiating amount. What they're talking about are Title IV federal benefits and some state benefits that the child or the family may qualify for depending on a number of factors. And the subsidy is available for the child going into the future. We'll talk about that in a second, what some of those subsidies are. And then finally, you will schedule a consummation date. There's your happy adoption day. It's the best thing ever. I usually, when I'm there or doing them, I have to just run out of the courtroom because I don't want to be involved in all those emotions. It's overwhelming. So the alternative to this process, where TDFPS is not the managing conservator, you have to hire an attorney for in your area that's familiar with your courts. You have to pay for and get a court-ordered adoption evaluation. You have to pay for your amicus attorney 100% of the time, 100% of the fees. You have to pay for your background checks, and you have to pay for all of the legal documentation to be prepared by a lawyer. You may or may not have to schedule a trial for termination and adoption. And so the fees can be incredible. And that's the balance. So I thought that was a nice thing since we're talking about adopting from foster care, to show the juxtaposition of what could happen. Now, this could also happen for a foster parent where they have chosen to take managing conservatorship or PMC with termination. They could be left in that situation. It does happen. Okay. Now, after an adoption, this is a very, very common occurrence. I get a lot of calls for this in the past 2 or 3 years with post-adoption questions. So we're going to talk about what subsidies are available and kind of some things that I see post-adoption. So when you adopt through TDFPS as a foster parent, generally speaking, most foster parents should qualify for some adoption fee subsidy, which will pay like $1,500 per child for the attorney fees involved. In most counties, the adoption fees for just filing the adoption are around $400. Most attorneys that handle subsidized adoptions will do it at no cost to the foster parents or very low cost. If you adopt through CPS, you will likely qualify for, in most circumstances, for monthly subsidy payments until the child reaches 18 years of age. However, those are part of this subsidy negotiation, so not something to be counted upon. The child should qualify in most circumstances for Medicaid until they reach the age of 25. And I think this is probably the most important benefit that a child should receive post-adoption, is counseling and other post-adoption services for the family. When you consummate an adoption in Texas, there is nothing more permanent about the family code. You could get married. They used to make it really hard to get divorced in Texas. Now it's relatively still hard, but it's, but when you consummate an adoption, there is no return, there is no refund, there's no backing out, and this is a lifelong commitment. And these children that you are fostering and caring for and loving, they might need a lot of help. They might have been through a lot, whether there's medical needs or behavioral needs. And so as they get older, I get calls where people say, like, we can't do this anymore. We need help. I need someone to take this now unruly teenager who may have been violent or something, and to help me get some assistance. So CPS has post-adoption services, and most agencies that are facilitating this have post-adoption services that are available. And having to navigate that process is hard, and it's not easy, and there's not always a solution, but they're there when you adopt through CPS. And um, finally, adoption records are sealed. To obtain them, once the adoption is sealed, requires a court order. And I balanced all of this with a private adoption. When you do a private adoption, you're not entitled to, any particular post-adoption service unless your particular agency that you adopted through just happens to have some services for you. Some of these things that we're talking about in post-adoption services are, maybe inpatient mental health services, or substance abuse issues. Those things come up, and it's when you take on adoption, it's you've got that child for better or worse until the end. And I think that if you understand that the same rule applies with if you have a biological child. So I don't think it's something to be scared of, or walk away from foster care because you have your own teenager, you have teenage problems, and that happens with foster kids. Next is some legislative changes. This September 1st, there's a huge series of bills that were passed that go into effect in the next 2 weeks or so. And there's been some changes in the past legislative sessions that I think are really important to talk about and affect foster parents who might want to adopt from foster care. There's been a trend over the past 4 to 6 years that has limited the ability of the department to remove children in non-emergency situations. And so I think the reason that's important is that the effect is that children who do enter foster care have almost necessarily been traumatized in a way that I'm not going to understand. And even as a foster parent, you're going to have a really hard time ever fully appreciating what they've been through. And that's okay. I think most trainings at your agencies will address these things, but the application of those trainings is going to be more important as you move forward trying to adopt through foster care. A big change as well is that termination of parental rights as of September 1st can no longer be based upon a legal ground that a parent failed to comply with the court-ordered service plan. The impact of that is not really known, because it hasn't happened yet. We haven't seen any cases come through, but I can tell you that it was called the O grounds, 161.001 subsection B10 of the Texas Family Code, allowed for the termination of parental rights when a parent failed to comply with the court-ordered service plan. So what would happen is CPS would draw up a service plan for a parent and then order that they comply with that service plan. And then if the parent did not comply with that service plan, then their parental rights could be terminated if it was in the best interest of the child. Now that has been removed. And so, in my opinion, the effect of this is likely to cause CPS and their attorneys to focus on trying to terminate parental rights on much more harsh consequential grounds, and it also may disincentivize a parent from actually working services that the department will provide. And it'll be interesting to see how the department, and their attorneys respond to this as the litigation proceeds. Then another legislative change that I think significantly affects all foster parents in the state of Texas is that there's a limitation going into effect on September 1st that will limit the legal standing of any non-parent, which would include relatives and foster parents. It limits their standing, and standing is a prerequisite to becoming involved in the litigation process. Foster parents as a whole must wait without question after September 1st for 12 months prior to filing a petition in intervention, which is the document that you need to become a party litigant to a CPS case. So if there's someone here that has that going on, they probably need to contact an attorney now, because the law, once the law changes, that it'll be a bar. Now we're going to talk a little bit about the role of foster parents and their rights, and then I'll be happy to answer questions. So I drew these up based upon the literally like thousands of cases that I worked as an attorney ad litem. I spent many years working with foster parents and going into their homes and going to court for the kids. And the role of a foster parent is critical, whether you're in the legal risk phase or in the legally free phase of a case working with adoption prep. But throughout the case, you're designated as a foster parent to make all the medical decisions for the child. Of course, there's exceptions to each of these, but I've had a kid that had leukemia and we needed, state office to approve treatments. But otherwise, all basic medical decisions and major medical decisions are going to be made by the foster parent. The educational decision making, all made by the foster parent. Behavioral health, getting therapy, speech therapy, occupational therapy, to support them in their development. All of those decisions are put into the hands of the foster parent, and foster parent is also in charge of all of the communication about those things. They're oftentimes not informed about the significance of that last part, the communication of this. But when you really think about the nexus between a CPS worker and a CASA volunteer and a child's attorney ad litem and a foster parent, the source of all the child's information is primarily from that foster parent. And where is that information going? Why is that even important? Is because ultimately all of three of those people are going to be communicating to the judge. Think about that. So a foster parent's role is getting all the medical information, making those decisions, the educational information, making those decisions, behavioral, and then they communicate this to the caseworker. So to me, that role is tremendous, and how the information is communicated and whether it's communicated at all is going to affect the decisions that CPS caseworkers communicate to their supervisors. And so ultimately CPS makes a decision based on information that is provided by the foster parent, gathered by the foster parent. And the child's attorney, they're going to go do a home visit, we hope, and get information from the foster parent. And maybe they'll get other information from home visits and things like that. But as an information source, that's a huge and powerful role of a foster parent, that they should appreciate that it's usually a one-way street. The information goes to the agency or goes out, and they may not get any feedback until there's a court hearing, which is where the rights of a foster parent come in as well. You do have a right to participate in certain staffings and meetings that the department has. The best way to go about this is typically to just have a good relationship with your caseworker, to encourage foster parents to participate and understand that, they might feel, a foster parent might feel like, no one's listening, and an appreciation of that role and those rights to participate in the meetings can be a difficult balance. They care about this child and they care for this child every single day. So if they can be encouraged to participate fully in the process and understand what parents are going through and how these decisions are made, then you have much more likelihood to come to those places of voluntary terminations. Foster parents have a right to attend court proceedings. In certain hearings, under certain provisions of the code, the judge does have to allow a foster parent to speak. But it's they're the judge, it's their courtroom, so tread very carefully. They don't have to listen. They have to maybe let you speak, but how long and whether they even have to listen to what you say is completely up to the judge. Now, under the current or the future legislation, after 12 months, a foster parent has a right to establish legal standing in a case. That doesn't mean that if you file your suit, you're going to win. It doesn't mean that, anyone's going to agree with you. As you go through this process, your foster parents, I encourage them to understand and appreciate that they have a right to privacy. They also have this right to participate, and that's a balance where there are trade-offs. If my thought process on it is that if you're going to foster a child for any length of time, you should go ahead and do the child the benefit of getting to know the parents, getting to know the process to the extent that it's safe and appropriate. There are situations it might not be, but being a part of a child's life, being a part of their foster parent, you're never going to take away the fact that this child has biological family and biological parents, and a good foster parent that's well trained and appreciates this process and what the child has gone through, and going back with what is in the best interest of the child, will be comfortable getting to know those people. And I would hope that most caseworkers and most child advocates can also appreciate that there's, if we can connect these people, then we can work as a team. And it should usually be really obvious at the end of the case, when you're standing in front of the judge, what's in the best interest of a child. Maybe some people don't want to admit that when it's time for trial, but the facts usually control. With that, I hope this has been helpful in understanding this process. Again, it's complex, and I'm happy to answer any questions that anybody might have.